Welcome, everybody. My name is Ann Callaghy, and I am the Director of the Government Benefits Practice at the Legal Aid Society, which encompasses HRA-issued benefits and Social Security-administered benefits. Today, I'm going to be giving an overview of SSI and SSD benefits, how a person applies for them, how a person can appeal denied applications, and a couple of other sort of basic issues. So this is essentially what we'll cover today. If you have questions, I think the idea is that you put them in the Q&A, and then Tess will let me know. And every so often I'll stop and see if people have questions. I think we'll do it as we go because that's when it's occurring to you. So we'll see how that goes. Also, I think I want to say this before I forget, that the Legal Aid Society represents people who are appealing denials of SSI and SSD. So if you have clients who need help with an appeal or a hearing, you could let me know that, and we can plug them into our intake and review their case for possible representation. So I just want to say that to you and let you know that we are a resource. The very last slide has my contact information. I wanted to start by just showing you some, and I think you're going to get a copy if you don't have it already, of this PowerPoint. So some good contacts for Social Security. First of all, their website is very useful. It has their rules, it's searchable, it has contact information, it has explanations. So it has ways of appealing and applying, which we'll talk about a little bit more. They do have a page of COVID updates, which I guess officially, are we not in COVID anymore? But some of the COVID stuff is outdated, but you can check online there to see what they are still putting into practice with respect to COVID precautions. They have a toll-free number. You may know that Social Security has hearing offices, but they also have local field offices for every borough and for every zip code in every borough that people are assigned according to their zip codes. So if you need to find a client's field office, you could go to the website here and plug in their zip code. During COVID, at some point, they had the actual phone numbers of the field offices. They don't really have those anymore. They just have the toll-free number, which advocates have complained about, but they don't seem to have reverted to giving us the actual phone numbers. If you were ever stuck, we could probably find it for you. You know, there are lists of advocate contacts. And so if you really needed it, we could try to find it. There are individuals that work for Social Security called public affairs specialists. They are listed at the website given here. They are people who can help troubleshoot when things are not going well for your client at the field offices. The New York Regional Office, this is their email address, and they are helpful when things are not going well either at the field offices or at the hearing offices. If a person has a hearing and you're not sure where it is, this is the website where you can plug it in and find the address, the phone number, the fax number of the hearing offices. I mentioned public affairs specialists. They are a big help to us. When a field office is not getting back to us or our clients, we reach out to one of these people, depending on what the borough is, by email and say, this is the problem. And more often than not, thereafter, staff from the field office reach out to us to say, oh, what did you need? So they are effective at their jobs. They also understand that the field offices are dysfunctional a lot of the time. That may be from overwork, it may be for a variety of reasons, but they recognize that and they know their job is to kind of help fix it. So they are a helpful group of people to know about. I wanted to go through basically the differences between SSI and SSD. SSI, now, before I worked with SSI and SSD, I could never keep them straight. And maybe most of you know it. A lot of you in healthcare and in the supportive housing, you probably get the difference. But for those who don't, supplemental security income is SSI, and Social Security disability benefits is SSD or DIB. And you see, I have two titles listed, and that's because each of these benefits was created under a different title of the Social Security Act. Kind of a way of thinking about it, the difference is that SSI is a federal welfare program for people who have disabilities that keep them from working. It's a poverty program. So they have more stringent non-disability rules of eligibility than SSD has. SSD is the program that pays people who have worked on the books and paid into the Social Security system long enough, and then who become disabled and unable to work. So if you or I became disabled, we might get disability benefits. It would be SSD benefits that we'd be getting because we paid into the system. For many of our clients who don't have a long enough work history or any work history, but they're too disabled to work, they can get SSI. It's a means-based program. People can get it for disability. It becomes considered an old age benefit at 65. A person's income needs to be taken into account to see if they're eligible. Their resources count for SSI. You can't have essentially more than $2,000 in the world, or you're not eligible for SSI. There's no resource limit for Social Security disability benefits, you see? So working people probably have like a 403B or some retirement account or some savings, and they're allowed to have that and still be eligible for SSD benefits. SSI, since it's a disability welfare program, it's a program of last resort. So you have to have less than $2,000 in the world in order to qualify. On SSD, if I become disabled and I have a child under 18, that child, who I presumably used to support, can get some benefits on my account. SSI, since it's not based on having worked, so the presumption is you're not actually losing income, and your dependents aren't losing income. Nobody but me can get SSI. Nobody but the person with the disability can get the SSI. There's no spousal benefits, there's no survivors benefits, there's no children's benefits under Title 16 SSI. The amount that a person gets for SSI is set by statute. So right now it's $914 a month. Every year it potentially changes if there's a cost of living increase. SSD amounts are set by how much your earnings were. So the more earnings you have in your history, the higher your SSD rate is. People can get a combination of SSI and SSD. If they're let's say I worked, but I was a low wage worker. So my SSD amount that I'm entitled to is not even as high as the statutory SSI amount. I can get a supplement to make up the difference. And we'll see that the application methods are different. Generally, the rules for SSD are more expansive and liberal than the rules restricting SSI receipt. The way the two programs are similar is that for both, you have to meet this statutory definition of disability. The evidence you need to prove disability, that whole process is the same. The process of being analyzed, your disability being analyzed by Social Security, that's all the same. The appeals process is all the same. And the definition of disability is very specific. So people who have the feeling that anybody can get disability and it's all kind of mushy, it's not that mushy. One has to show as Social Security that they have the inability to do any substantial gainful activity, which is, working enough, which is about $1,300 or $1,400 a month. If you can earn that much, they're going to find you're not disabled. And it's an inability to work by reason of any medically determinable physical or mental impairment, which means some doctor, some medical professional has to say you have a diagnosis, either a physical or a mental diagnosis. And that diagnosis, that medical condition, has to be have lasted already for 12 months, or be projected to last for 12 months, or to end in death. That's the definition. So that if I am terribly sick for 6 months, and it ends, and I couldn't work during then, I would not qualify for disability benefits, either SSI or SSD. If I have a condition and I'm at the sort of the start of my diagnosis, but it's a condition that they say, well, like this is not going to end in 12 months. And I have doctors who will say that, or it's known in the medical field, I could qualify, at least meet the eligibility criteria for that part of the rule. We'll talk more about that as we go along. Before I go on to how to apply, are there any questions?
Okay, 1 second.
Okay.
So does someone need to be out of work for a period of time in order to be considered unable to do anything, unable to do any substantial gainful activity?
Not as long as they can show that the medical condition that has them not working is expected to last at least 12 months. Yeah.
And would you mind repeating the amount that a person can make in a month?
Yes.
Sorry, where they will not be approved?
I know. I think I have it on the next slide, and I am doing a quick search. $1,470 is substantial gainful activity for 2023. Okay. Now, that's not to say, so that's just that criteria. But if a person's working full-time and making less than that, they may still be found not disabled, because Social Security is going to say, look at you, you function full-time. So even if you don't make that much money, it's going to be hard to find them disabled if they're working full-time. But that is the criteria for substantial gainful activity, 1470.
Mm-hmm. Okay. And can you apply for both benefits at the same time?
Yes, you can. And it's often, at least for, I'm saying our clients, and I'm assuming that we all have low income clients that we serve. It's often beneficial to do that. So even if a person has a work history and might qualify for SSD, because it's often too low, they should also apply for SSI in case the SSD is so low that they would qualify for some SSI. And it ends up being a joint application. You're not doubling everything by applying at the same time. And also the disability determination will apply to both programs. So it's kind of better if people apply jointly. Yeah.
Can a person receive SSD and Social Security retirement income?
You know, SSD, Social Security Disability, is what you get before your early retirement age, which for most people is 62. And once you're of retirement age, the amount doesn't change, but the category changes. So now it's no longer considered disability benefits, it's considered retirement benefits, if that makes sense. So no, you don't get both.
Thank you for clarifying. Another thing to clarify, someone mentions that their clients often say SSDI, but here in this training, we're saying SSD. Could you provide some clarification on that?
You know what, there are just acronyms that all are interchangeable. So the SSDI and the SSD and DIB, disability insurance benefits, they're all the Title II benefits based on earnings. The SSI is SSI because it's supplemental security income. It's too many S's in both of them, frankly, but so that's all Title II.
What about if someone has short-term disability? I think you mentioned this is, if your disability is going to last at least a year. Do you have any insight into what you can do if you have a short-term disability?
Well, I'm not an expert in this, but there may be New York State short-term disability, and then a lot of times it'll depend on what your job offers. But Social Security is a whole different administration with different benefits. So it's sometimes the state, sometimes the employer has something. Otherwise, if I can't work, then it's public assistance. That's not disability, but that's like the minimum.
And real quick, everyone, I see you all putting questions into the chat. If you could add it into the Q&A, it's much easier for us to keep track of that way. Thank you. Can a person be approved for SSD if they also get Medicaid, regardless of their assets?
They also get Medicaid. Yes. If a person is on Medicaid, I have like 1,000 questions that raises, but getting Medicaid is not a bar to getting SSD. When you qualify for SSD, you will qualify for Medicare. But if you also qualify for Medicaid, the Medicaid ought to pay your Medicare premium. So you might get both Medicaid and Medicare. On SSI, you will only qualify for Medicaid. I hope that answers the question.
Okay. This was an anonymous question, but if you would like to add any more details to your question, feel free to send those along. Okay, we're getting a lot of questions. Is that okay? Do you want to keep going or?
How about if I talk about the application process, and you may find your questions are answered as we go along, and I'll stop again.
Perfect.
And we'll do more questions if it wasn't covered. How's that?
Great. Sounds good. Thank you.
I mean, I'm happy to answer questions, but let's see how it goes. So there are different ways of applying for SSI and SSD. A person can apply online. It's a bit different for SSI than SSD, and we'll talk about that. A person can apply by phone, and a person could apply in person at a field office, but they recommend, Social Security recommends, and so I would suggest it's easier to do that by making an appointment either by calling or going online. And online is always ssa.gov, and they do have decent tools. So there's like a schedule an appointment button, and you fill out some basic information. And for SSI purposes, once you fill out that and request an appointment, you get what is considered a protective filing date. So like that'll be considered your application date as long as you follow up and finish the application within probably 60 days. But so it's a very good tool for getting you started. And the advantage to locking in a protective filing date is for SSI, for SSD too in its own way, but for SSI, you can't be paid before the date of your application. If I apply now, and here we are in February, the earliest I can be paid is starting in March. So if I can't get myself into the office to do it in person until March, if I've gone online to ask for my appointment, I get the protective filing day of February. So if I wait till March, I can't start to be paid until April. So I miss a month. So anyway, these are our methods. I'm going to say something a little bit more about what they have developed as a vulnerable population liaison. I find it difficult to say. A program that Social Security developed because in COVID, they had such a drastic drop in the number of people applying for SSI that they realized, oh my goodness, people are out there and they can't apply. So they developed this program to help make the connection and do some assistance. So we'll talk about that in a bit. There are differences in the rules of who can apply for SSI online versus who can apply for SSD online. And the SSI, as with everything, is more restrictive. So if you are say you have to be an adult between 18 and 65 to apply online for SSI, you have to have never been married. You can't have your disability be blindness. You have to be a US citizen in the 50 states, Washington, D.C., or the Northern Mariana Islands. Notice that residents of Puerto Rico are not eligible to receive SSI if they're living in Puerto Rico. This is an ongoing issue. If you haven't applied for or received SSI in the past, and if you are applying for SSD at the same time as the SSI, all of those mean that you could apply online, but you're still going to have to go sign a paper form. So, it's a relative access that you have. The vulnerable population liaison is something that you might want to know for your organization, because if you're advocating for people, Social Security will work directly with you and their liaison to connect, to advocate for the expediting of your client's applications, to have a person to contact when you have, or the claimant has documents to submit in support of it. Basically, it's a way of having things run a little more smoothly with your client's application, because there's a real person that has their eyes on it. And you know how things get lost at agencies, and Social Security is no different. If your organization is interested in participating in the program, you can contact Everett Lowe, and he's in the Regional Commissioner's Office in Manhattan. He's a very responsive person. It's his job to be responsive. They are happy to make the connection and allow us sort of access to advocate in this way for our clients. After a person applies online for SSI, Social Security will mail the claimant a notice with an interview date. We have noticed, to speed up the interview scheduling, call the local field office about a week after submitting the online request for the interview. Giving people a poke often helps. During the application process, Social Security gathers medical evidence, the treatment records from a claimant's medical providers, mental and physical doctors, physical therapy, psychotherapy, all of that stuff, and any tests and test results, all of that. Social Security will often send an applicant to their own contracted doctors, known as consultative examinations. These are kind of cursory exams, and then that doctor will do a once-over and write a report and submit it to Social Security. They are often not that helpful. They're kind of narrow in finding that our claimants meet the requirements of disability. They often are very generous in what they say our clients are able to still do physically and mentally. So it's always better for a person, if they can, to get their own treating doctor to render an opinion in writing about their condition and how it affects them. Cases will then be sent to what's known as a disability analyst, and there's a group of disability analysts that really, they're contracted with Social Security, but they are based at the state agency, the Office of Temporary and Disability Assistance. Sometimes we call it OTDA. That is the State Department of Social Services. That disability analyst reviews the medical evidence and makes the medical determination of whether a person meets the definition of disability. If you are assisting, you can help the person gather medical evidence and doctor's reports. That stuff should be sent to the disability analyst, not the local Social Security office. And the claimant will get a letter from the disability analyst at OTDA saying, I'm looking over your case. I need some more things. And it'll have a person's name and their phone number. And you can call, if you are advocating, you can call that person and say, what do you think you need? Or you can say, I think you have enough to find them disabled. Look at this and this and this. And we've had some success pointing a disability analyst to the evidence that they already have and have them realize, oh, yeah, you're kind of right. So that can be effective. We can help claimants in a variety of capacities. We might be an authorized representative, and that means we've signed and they have signed an appointment of representative form, which is a Social Security form. That can be signed a hard copy and mailed or faxed to a local office. That can also be done online at ssa.gov if the claimant has an email address. If you can do it that way, most of our clients don't find that very easy, but if a person could, it's a nice way of doing it because it's in Social Security system. Otherwise, you are faxing to a local office or you're mailing to a local office, and then you're following up to say, can you check the fax machine? And okay, I'll fax it again. And now that you have it, can you please register this in the system? Like, this is a kind of annoying part of the advocacy. If you're not an authorized representative, you can still have a claimant sign a consent for release form, which is Social Security's Form 3288. And this slide shows you where to find it on ssa.gov. Googling could be your friend. You could find it that way. And it'll allow Social Security to speak to you about the case. You can help a person to gather medical records, or you can suggest that they gather medical records from anybody who treats them. Psychiatrist, therapist, physical therapist, occupational therapist, physicians, primary care physicians, specialists, all that stuff. They can get opinions, medical records. Sometimes old school records help when somebody has a cognitive disability and we want to show there's a history of it. For some purposes, we want to prove that a person, for instance, was diagnosed with a cognitive disability before the age of 22. So getting old school records is helpful. Sometimes housing records, if somebody lives, let's say, in subsidized housing, and maybe those records reveal that, or if they live in supportive housing, it reveals what services they need or what accommodations they've been given. And that would serve to show limitations they have due to their medical conditions. As far as old school records, if a person was in special education in New York City, requests for those records can be mailed to this individual at this address. In COVID, it became a tremendous backlog in his office. So that office prioritizes subpoenas from judges for these records, but it is worth making the request, or at least alerting Social Security that these records exist, because they are supposed to develop the claimant's record. And that is a main concept that we try to hold Social Security to, the obligation to develop the medical record. Years ago, I had a claimant who was 55, and really her main disability was intellectual disability, which in Social Security's lingo then was called mental retardation. She went to special ed in New York City, and even at 55, I got her medical records and her school records. And yep, it showed her IQ before age 22 was like, in the 50s. So she got her SSI. So now I'm going to turn my attention to what happens after an application's denied. So why don't I pause here and see if there are questions?
We definitely have some questions going on.
Okay.
Okay. So you think it's a good time to ask questions about sort of like eligibility?
Yeah.
So someone is looking to clarify, if a person is going to be 62 and wanted to apply for SSD, would the person be able to roll over the SSI retirement income?
The SSI retirement income. I don't actually know what that means. I'm sorry.
I'm sorry, the Social Security retirement income.
Oh, to roll it over. Social Security will give you what you're eligible for. So we've had clients apply at age 62 for disability benefits. They are approved for retirement benefits at a lower rate than their full retirement benefits would be, right? Because 62 is an early retirement age, and get denied for their disability benefits. So they appeal it. And if they're approved for disability, they'll start getting paid at a higher rate. But they're not getting both retirement and SSD. It kind of becomes the higher rate of retirement benefits. because they're found disabled. I don't know if that was very clear, but you can't get both. You're going to get the higher of whatever they think you're eligible for.
All right. If a person does not qualify for Social Security at the age of 72, can they get SSI?
At the age of 72?
Yes.
Yes. So you can qualify for SSI by based on age starting at 65. And at that point, you don't have to prove disability. But there are other requirements, like you can't have too much money in the world, not just in the bank, sort of anywhere, more than $2,000. You can't have an income that's higher than the SSI amount per month. You have to have the right immigration status. There's a whole, you could have to be a citizen or a qualified alien, and there's a whole list of what a qualified alien means. So there are like non-disability criteria. Assuming you meet that, yes, a person at 72 could get SSI.
Okay. Does SSA fall under the same category as SSI?
SSA, is that the question? So Social Security benefits and Social Security disability benefits and Social Security retirement benefits and Social Security survivors benefits all come under the rubric of Title II of the Social Security Act. And SSI is supplemental security income under the rubric of and created by Title 16 of the Social Security Act. So that's how they separate them out.
And what is the cap on the assets that a person can have?
The assets, you can have $2,000 as an individual, or if you are a married couple that both receive SSI, you can have $3,000. And we're talking in the world. So if I have money under my pillow, or I have property that I don't live in, that's a big problem for a lot of our clients. When they have a house in the DR or a house somewhere else that they're not living in, that is a resource. So 2,000, 3,000.
Okay. And so what happens if suddenly you have more than $2,000 in your account? What are you automatically stop receiving payments, or sort of what happens?
Yeah, I mean, potentially, yes, but Social Security. So if you go over $2,000, one, you're supposed to report it. When that happens to people, it's often like they didn't spend their money fast enough, or it also, people got COVID money. So that pushes them over $2,000 is not supposed to cut them off, because COVID money was exempt for those purposes. But and often Social Security is not that swift. So they may notice months down the road that you started having more than $2,000 in the bank a year ago, and they'll send you a notice saying you're no longer eligible and you have an overpayment. So we're going to talk about overpayments. We'll talk about how to appeal. You have appeal rights with any adverse notice that you get. And so, yes, essentially over 2,000, you're not eligible anymore, but there are things that you can do. Including, you can spend it down to under 2,000 again, but keep receipts to show how you spent it, because you can't give it away. And like I said, you can't stick it under the mattress. Like, they have to know it's gone and what you got for it.
Um, so there's some questions about the appeal process, but I think we're about to get into that next, so I'll hold off on those.
Mhm.
How many years of work is needed for someone to qualify for SSD?
SSD, unless you're young, it's like under 30. It's 10 years. It's considered 40 quarters of work, and every year has 4 quarters to it. So it essentially is 10 years of work on the books, paying into the Social Security system.
Someone's asking why blindness does not qualify for receiving SSI.
That I was unclear. It does qualify for receiving SSI, and they receive it at a higher rate. And the SSI program is more liberal in its rules of eligibility for those who are blind. And I think it's just they had, I don't know, maybe the government finds that like a sympathetic disability. It's also kind of undeniable. And they had a strong lobby at some point. And good. But it is treated differently, but they're totally eligible, but at a higher rate.
Okay.
Yeah.
If a person attains citizenship but never worked in the United States, would they be eligible for benefits?
You could get SSI. But if you have no work quarters in the United States, you couldn't get SSD. You have to have paid into our system. I mean, they might get it from the country they worked in.
Okay. So some questions about like gathering evidence. Should you apply and then gather documentation? Or should you have your documentation ready and then apply? What would you recommend?
Yeah, I wouldn't, if you have it good, I wouldn't wait to apply until you have documentation, because that can be pretty drawn out. And you don't want to delay filing the application, because the application date sort of starts your eligibility date for benefits. So I would apply first, and it's not the quickest process on earth, right? So it's going to be 3 months before they make your decision anyway, because they'll send you to doctors and they'll gather evidence. And so you have months before they make a decision to gather evidence after the person applies. And I keep saying you as if like we're all applying, but you get it. Your clients, whoever.
So then this question says, does SSA require that you obtain medical and mental health documentation from your providers, or will the SSA reach out to them and get that information?
They'll reach out to them. And part of the process is Social Security will have the claim that the applicant sign HIPAA forms and release forms for the purpose of asking for them. I don't know how thorough sometimes Social Security is in asking for documents or following up if they don't get an answer. So if an applicant is able to do it themselves, they should, because then we'd be more sure that Social Security has relevant stuff in front of them.
And everyone, I'm seeing a lot of really important questions in here that are a little bit client specific. And some of them I think are really broadly applicable here, but if I'm not answering your question, it's because I think we're going to end up offering a session we've been calling Ask a Lawyer. So following this, we'll have an hour-long session at a later date where you're going to be able to come in and ask some more client-specific questions to Anne. It's not legal advice or anything, but like officially, you'll be able to get into some of the more details of your questions. Let's see. Here's a question. You did mention that a person can apply if they receive if they have a 403B. But what if the retirement funds are above 2,000.
Yeah, if then for SSI purposes, then your resources are too high. So, and I know all of us are going like, yeah, but if I take the money out now, there's a huge penalty. It doesn't matter under the rules, because they're going to say, yeah, but you have this money. So they do count as resources.
Okay.
It would have to be a resource is money that is available to you. And that money can be made available to us. So unfortunately, it makes a person ineligible for SSI.
All right, that's tough. When a client turns 65, what happens to their SSI?
It continues. It just is moved into the administrative category of old age benefits.
Someone's looking for clarification about if someone was previously married, that means they're not able to apply online.
Yeah.
Okay.
For SSI.
Can veterans get VA benefits and SSD?
Yes, it's budgeted against the SSD. And there's a formula for doing that, which I can't tell you. But yeah, so it would be like a reduced amount of SSD. What happens to veterans and also people who are in receipt of workers' compensation, Social Security messes it up a lot. And so like I sort of in the other situation that I mentioned, like down the line, they're going to go, oh, you have these benefits. We never budgeted them. Like you have to report it. But even when you report, they often don't rebudget.
Mm-hmm.
And then they go, you've been overpaid for all of these months. So they are supposed to do a reduction.
Okay. How long will Social Security wait to receive medical records?
Before making a decision, I guess that means.
Yes.
So, they'll send you through the process. They'll make a request for the records. They might make a second request for the records. They'll send you to their doctors. They'll send whatever they have to the disability analyst. All of this takes months. The disability analyst, if they need something, might write to you saying, I'm missing something. But pretty soon, like thereafter, they're going to say, okay, I'm making a decision. So that's months. But if there's an advocate on the case, and presumably the claimant could say, could you just wait a few weeks because I'm going to get something? They will. But it's still going to be within a 3 or 4 month time frame. Now, right now, there's such a backlog. I kind of think there's little fear of them making too quick a decision. So you have time.
Fair enough. All right. I think let's get back to the
Okay. So let's talk for a bit about what happens and what people's rights are when I'm saying when, let's say if the application is denied, but many get denied. Which, goes against the whole, I'll just say this editorial comment, the kind of stigma that people can get disability benefits easily and willy-nilly and it's, in my experience, that's not very true. So if the application is denied, Social Security is required to send a notice of the determination. And that is supposed to contain, and since it's a pre-printed form, it does, what a person's appeal rights are and the deadlines for appealing. And let's go through some of them. When an application is denied, there are then 4 levels of appeal, right? You can sort of keep going. You can file a request for reconsideration, and that is something you can do online or by fax or by mail or in person. Social Security does not encourage anybody to come in person at this point. A request for reconsideration, please reconsider the denial. The field office looks again. Let's say they deny it again. Then a person has the right to request a hearing by an administrative law judge. That can also be done by those other methods. Online is a great way to file these appeals because they don't get lost on a fax machine. And others can file the appeal for the person without being any official representative or any official anything. I could file it online for my friend. If after a hearing, the administrative law judge, the ALJ, denies the application, then a person can request a review of that ALJ decision to the appeals council. So this is still the appeals council within Social Security. If the appeals council denies the request for a review of the decision, then a person can file an appeal in federal district court. In New York City, that's the Southern District in Manhattan or the Eastern District in Brooklyn, depending on where a person lives. That's the court that they should file in. Once the case is decided by the appeals council, the administrative process is over. And then you're in the court system if you want to be. I'm not sure if I have this on a later slide. I'll say it now, though. A person used to be able to appeal at every level and file a new application, right? To do both at once. If you're familiar with cash assistance and SNAP from HRA, you know that a person could file for a fair hearing and reapply. But Social Security no longer allows that. So a person always has to decide either to appeal or to file a new application. And that is a case-specific decision. Unless a person has a brand new disability that just cropped up, I think appealing makes sense. But like I said, it's a very individual decision and you have factors to consider. Once you get to federal court, you could file a new application and file an appeal in federal court because you're not in the administrative system anymore. There are time limits for every level of appeal, and they are the same at every level. So you get 60 plus 5 days from the date of whatever that denial decision was. So you get the notice denying your application, you have 60 plus 5 days. You get a notice of denial after the reconsideration, 60 plus 5 days to now file for a hearing. If the ALJ issues an unfavorable decision, you get 60 plus 5 days from the date of the ALJ decision to file at the appeals council. If the appeals council denies requests to review the ALJ decision, you have 60 plus 5 days to file the case in federal court. It is possible to file a late appeal. And as long as you can show what the good cause reason is for filing late, it's in Social Security's regulations. They recognize that things happen in people's lives. They recognize, at least on paper, that the people filing these appeals have deficits in functioning. That's the whole idea. That's why they're pursuing this. And so they recognize that there may be reasons why a person files late, and they give you a chance to allege what your good cause is. And so some of the reasons are listed here. Did the circumstances cause delay? Did Social Security's actions mislead you? Did your mental or physical limitations prevent you from filing on time? Was there a language barrier? You didn't understand what the notice was. You had nobody who could read it to you. It wasn't in your language, or you are illiterate and you cannot read it and you have no one. Really good cause is, and you can explore it with your client, like what happened? Why were you late? I was in the hospital. I had an emergency. I had a death in the family. And you can tell that story or help them tell that story. In COVID, they were much more lenient in granting good cause because they recognized, they being Social Security, that COVID was an unusual circumstance. People were sick, were compromised, we were suddenly remote. They haven't said that that's all over and we're not going to be lenient anymore, but I don't know how lenient they're going to be now. But good causes has always been a concept that they recognize and always a right a person has to allege. So it's still worth alleging it now. How late is too late? So, if you are a week, a month, maybe even 2 months, depending on your circumstance, but a year, I probably wouldn't do a year. I'd probably reapply at that point. So that again is an individual decision. But I guess I want to say all is not lost. And so it may very well be worth alleging good cause. This applies to every level of review, including missing a deadline to request a hearing. And we've had lots of clients who have good cause granted and then they get their hearing. If you miss your hearing, good cause applies to that too. So I guess my theme is all is not lost. People miss hearings. They miss them for a lot of reasons. Maybe they didn't get a notice. Maybe they were sick that day. Maybe they got lost. Our clients get lost on the way to their hearings. They have nobody who could take them and they can't travel alone. It could be anything. Not anything will be granted, but there are many reasons why it might be granted. Call the hearing office as soon as you realize you missed your hearing. Use the number on the notice or use the locator listed here to find the local office number and call. The whole thing is, what are the facts, and try to explain them. Hearings now, they used to be held in person all the time. And then pre-pandemic, to deal with the backlog in New York City, hearings were farmed out to hearing offices in other states. New Jersey, Massachusetts, Chicago, Maryland, Puerto Rico, so those were held by video. And now in the pandemic, hearings have been held by telephone. Having said this, a person always has a right to an in-person hearing. And so you can decline a telephone or a video hearing and say, I want my hearing in person. And there may be good reasons for that. That's an individual decision. A person can say, no, I don't want anything but an in-person. There will likely be a delay in the scheduling of that. It may be worth it. A person may decide, I don't want a delay, and I will accept a remote form of a hearing. The average wait time these days for a hearing in the Bronx is 12 months. Those statistics are online, so they're sort of interesting to see. At some point before the pandemic, it was 2 years. So 12 months is about half of what it was. I think that's in part because of the remote nature of hearings. So I'm going to get into this whole section on how they think about medical evidence and decide that you're medically eligible. Before I do that, are there general questions about the appeals process?
Yes. So, sorry, one moment. How soon again can you reapply?
If your case is denied and you're not going to appeal at the administrative levels, you could just go in and apply. You could apply right away.
So, someone is asking for more information about the different levels of the appeals. Would you be able to either now go into it or share perhaps like a one sheet on this?
I could say a few more things. And if you feel like a one sheet, I don't think I have one, but I could create one. I mean, it's sort of, as you see those levels of appeal, I'm going to go back because they're listed. They're escalating levels of appeal. And it's kind of like people with greater and greater and greater authority and discretion are taking a look at them. And so when your application is denied, your request for reconsideration is still at your local field office. And you're still with that disability analyst taking another look at your case. And they have kind of a narrow view of the rules and how to interpret them. If you then need a hearing, an administrative law judge, they always say, review your case de novo, brand new. They don't have to abide by any decision that was made prior in your case. It's brand new. So that judge is taking a look at all the evidence, and they're going to listen to the claimant testify, and they'll listen to any witnesses, and they're going to look at new evidence, and they're going to listen to arguments, and that the judges exercise more discretion when there's a gray area and have a better understanding of the nuances than the disability analysts typically do. If they deny the case, the appeals council, they take a look and go, did the ALJ really abide by the rules of how you have to analyze cases? Or did they ignore evidence? Or did they fail to develop the record? Like, they knew you had medical records somewhere. They said they were going to get them. They never got them, and they denied you anyway. Or did they not really ask you questions enough about a certain topic, even though it was kind of flagged that this person has issues here? So they didn't develop the evidence in that way. Or did they indicate they had a particular bias in your case? So there are errors that are stated in the regulations that the appeals council looks for. And sometimes they'll send it back and say, ALJ, we disagree with your determination. We think a new hearing is in order. So give the person a new hearing and do these things at the hearing, and reanalyze the evidence in this way, because we think you did an inadequate job when you did the analysis. In very rare cases, the appeals council will say, oh, this is so wrong. You are just eligible. We're granting benefits. It almost never happens. If the appeals council denies review and a person goes to federal court, it is possible to do it, as we say, pro se, by oneself, unrepresented. And it's probably the easiest, it's not easy, but it's the easiest kind of federal appeal to do on your own, because there is a pro se office at the federal court for these appeals. Because Social Security is a federal agency, it's all about disability. They're trying to make it accessible. So they show you how to do it. If the federal court finds in your favor, they most likely also grant you a new hearing and tell the judge, these are the mistakes you made. Do it again. More rarely, they will find that you are outright disabled and we should just issue benefits. That will happen if you have gone through this process up and down many times and it's been years and you are severely disabled. They may grant your benefits at that point. But that's kind of how it works. Most of the time, the best you're going to do at the appeals council or federal court is to get a new hearing. You'll get a new hearing in front of the same judge as the first time. If they deny you again and you go through the process again and get a new hearing, it'll go to a different judge. They kind of get two shots at it. Mm-hmm. Like whoever can tell us if that was enough, but that's kind of the elaboration on it.
And so can you appeal like at all levels, or is there sort of a strategy for figuring out which level to appeal at?
Oh, so this is a consecutive appeal process. So you have to do the recon first and then get a hearing. And then what you're entitled to is the appeals council. And then you're entitled to federal court. You can't jump ahead. They have an order to them.
Great. What is the extension period for the late appeal?
Well, let's say I file late and I say good cause and they grant it to me. If they grant it to me, they grant it to me. So there's no set extension period because in order to have been granted good cause, I have to have filed my appeal. So the appeal will have been filed and they'll just say, oh, okay, we're going to allow this to go forward. Does that make sense?
Mm-hmm. Is it common for clients to be denied their first time applying?
Yes.
Why?
Okay. I think probably a third of the time they're granted. And then a third more are granted at higher levels. And then a third more at the highest level. So why? Because often Social Security doesn't follow up much on the medical evidence. So there's not enough stuff to show. Because I think the clearest cases are granted. And then the ones that take more complicated analysis of the rules and apply them to this client's case, that stuff doesn't happen at a very sophisticated level. So they get denied. Yeah.
Does good cause have to be provided by the provider, or is it by the person applying?
By the person applying. But if they have evidence to support their explanation, like here is my hospital discharge paper to show that I was in the hospital for a month or something beyond, if there's something that a doctor, like if I'm saying I cognitively can't appeal on my own and I needed help and didn't know how, and there was medical evidence, a doctor's statement that says, yep, this person functions at some low compromised level, then of course any evidence can help. If you have evidence, submit it, but it's not necessarily required. And what I find is at hearing levels, when you request good cause, or maybe at any level, they might come back and say, we're giving you a chance to submit some evidence to support this. And at that point, then you could go to a provider perhaps and get something.
You mentioned that in the Bronx, it takes about 12 months to go through the appeal process.
Yeah.
To have a hearing. Do you think that it kind of makes a difference if you're doing it in a different borough? We heard about the time for other boroughs.
You know what? I'd have to look up the time for the other boroughs, but it's not a whole lot better anyway. So it's a long time, but I can look that up. It's also Googleable, and Social Security publishes that statistic online of their own delays.
A lot of client specific questions that I think like let's get through, and if we have time at the end for some of them, let's do that.
Okay. Okay, I'm just checking the time to see where we are. Okay. Good cause, hearings. So now we're going to talk about the medical criteria and how Social Security analyzes it so that you can understand what's helpful in a client's case to produce. Again, there are medical criteria for approval and non-medical criteria for approval. The medical criteria is meeting that definition of disability. The non-medical differs, as I said, between SSI and SSD. You basically, for SSD, need to have worked sufficiently on the books, which is typically 10 years. And SSI, they look at income and resources and immigration status. But I'm going to go more deeply into the medical criteria now. And there is something called a 5-step sequential evaluation. There are 5 questions Social Security asks in order, in sequence, in order to determine whether a person is disabled or not. These essentially are the 5 questions, and we call them steps, and Social Security calls them steps. So step 1 is the client engaging in SGA, substantial gainful activity? Is the client working right now in 2023 and earning $14.70 or more a month? If they are, they're going to be found not disabled. If they are not, Social Security asks the step 2 question. Does the claimant have a severe impairment or combination of impairments? Medical impairments is what that means. So it can be mental or physical, and it can be, as it says, one diagnosis or a combination of diagnoses. When you put them all together for this person, it impairs their functioning to a degree that they can't work. So, but first you have to show you have some medical disability. I've had clients come who aren't working, but that was really because the company closed, and they can medically work. They just can't find a job. So that's not a successful application for disability. So if they do have a severe impairment, and that is considered like de minimis, it has to be something that does impair your functioning, but it's not like you don't have to be incapacitated. Most of the time, if someone has a diagnosis that impairs their functioning in some way, even mildly, that's an impairment. So we get through step 2. It's a rare case that's denied at step 2. So if they have a severe impairment, Social Security asks the 3rd question, the step 3 question: does the impairment meet or equal a listing? And we will go through that and what that means. And step 4, if it doesn't meet a listing, can they return to whatever work they had done in the past? And if no, or they had no work, Social Security asks, can they make an adjustment to other work? So now we're going to go through a little bit more in detail. Step 1, are they performing substantial gainful activity? In 2022, it was $13.50 a month. In 2023, it's $14.70 a month. Step 2, I talked about severity. So there has to be some limit, physically or mentally, or a combination of both. And that limit has to either have lasted 12 months or be projected to last 12 months. We talked a little bit about that. Step 3 is, does the impairment or impairments meet or equal a listing, a listed impairment? Social Security has listings for adult medical conditions. They also have separate listings for child medical conditions, and they track the ones here. But they break the human body system into separate systems. So you can see them listed here from 1 to 14. So if you have a bad back, that's under the musculoskeletal system. And there are very specific criteria and test results and limitations that a person has to have in order to meet the listing under the musculoskeletal system. Two, special senses and speech, meaning blindness and deafness and speech impairments all come under special senses. Asthma is under the respiratory disorders or COPD. Congestive heart failure and other heart-related cardiovascular problems comes under the fourth one, and so on. All of the mental health listings are under 12.00, the mental disorders, and they have a range under there of the cognitive and then impairments, mood disorders, and personality disorders. And under each one, they show what symptoms you have to have and the extent of the limit of your functioning. So you look at your client's diagnosis and then look at the relevant listing and see if it meets the criteria. If it doesn't, precisely, that's not the end of the inquiry. There's not just a denial. The next part of the inquiry is, does the person have work in their past 15 years? And that's known as past relevant work. If it's beyond 15 years, they're going to say, that's too long ago. We don't reasonably think you could go return to something you did more than 15 years ago. But so we'll look at anything you've done in the last 15 years that was substantial gainful activity for that year. And they're going to say, what is the highest physical and mental level that you can function at? And does that allow you to return to your past relevant work? And they're always talking full time, 8 hours a day, 5 days a week. If they decide, yes, that a person can return to their past relevant work, they're found not disabled, they're going to say, okay, so go do your old work. That doesn't mean that there is a job available for you or that you wanted that job or anything like that. It's a medical determination that you could do it. There's also very strange Supreme Court case law a couple of decades ago that says it doesn't even matter if the job exists anymore. So that's a problem. If they say, no, you can't return to your past relevant work because your limitations mean that you're unable to do it, they ask a fifth question, step 5, is there any other work that exists in the national economy in sufficient numbers that you could do? And they take into consideration your age, how much education you've had, what your past work experience is, what level of exertion you can do physically. Can you lift heavy weight up to 100 pounds? Can you lift medium weight up to 50 pounds? Can you lift light weight up to 20 pounds? Can you only do a sitting job? So you would only have to lift up to 10 pounds and most of the day you spend sitting. All the other ones you spend on your feet, essentially walking or standing for at least 6 out of 8 hours. So you see, they take a lot of factors into account when they look to see, could you make an adjustment to other work? Now, that all is physical. If you have non-exertional impairments, which include the mental impairments, you have trouble concentrating, you have trouble following through on tasks, you have trouble doing a series of tasks that you're given, you have trouble following instructions, you have trouble working around other people, interacting and relating. All of those are non-exertional impairments. That means they can't use a certain set of guidelines, which we call the medical vocational guidelines, which are kind of formulaic in order to deny you. They would have to kind of use a vocational expert to give an opinion about your functioning. And that happens at hearings. And when a judge should have had a vocational expert testify and they don't, and then they deny you, that's often a reason the appeals council sends it back and says, ALJ, judge, try again. You should have had an expert. As a kind of rule of thumb, it's harder to be approved if you're under 50, which Social Security terms a younger individual, if you're college educated, and if you have past relevant work in a sedentary job, because they will find it easier to say that there's other work you can adjust to. So by the same token, it's easier to be approved. The older you are, the less education you have, and the less skilled work you have, or if you have no work, that profile will be more readily approved. Person in their 20s, that's going to be hard, except if they can show that their medical condition meets one of those listed impairments. And so that's a very severe impairment with a very low level of functioning, either physically and or mentally. So our young clients, we often will find that it's hard to get them found disabled now, but as time goes on, the condition's probably not going to get better. It'll probably get worse, and they'll try again in 10 years, and maybe they'll be approved at that point. So this is kind of how it goes. Social Security has to consider medical opinions that are presented to it at every level of appeal. And they had a change in the rules. So applications filed after March of 2017 had a different way of considering medical evidence. It used to be your treating physician was given, that a person's opinion was given controlling weight in deciding the case, but that's no longer true. So now they look at the evidence as a whole and decide, is it persuasive? Is it supportable by all the other evidence? And is it consistent with all the other evidence? Having said that, they're still not allowed to ignore evidence in the file, to not consider it, to cherry pick is one of the mistakes they make. You know, I'll take this element that this doctor said and this element that this doctor said, and I'll pick out all the stuff so I can find you not disabled. They have to actually look at all of it and try to reconcile all of it. And this, when we are at hearings, we are pointing out all the things the judge should consider. When we are representing somebody who got an unfavorable decision, we are pointing out all the ways the judge ignored what the judge should not have ignored in the medical evidence. I am going to go on to a slightly more nuanced issue. So if there are questions at this point, maybe we'll talk about those.
Okay. Can people who are formerly incarcerated receive SSD benefits?
Yeah, they could qualify for SSD. They could qualify for SSI. The only rule, formerly incarcerated, you can't get benefits if you're incarcerated. And if you are a fleeing felon, you can't get benefits. But formerly incarcerated, you can. That's not a bar. I mean, there might be other reasons why you can't, but.
And the criteria you shared in this portion, is that only for SSD or?
That the medical criteria applies to both SSD Title II and SSI Title 16. And that is the way these two programs are the same. The whole definition and analysis of disability and medical evidence is the same.
Can someone over the age of 80 who's a green card holder apply for SSI?
They have to have been in the United States. Well, you know what? I have to look at those rules again.
We can follow up.
Yes, let's follow up on that one. If you can remind me of that question, because there's a couple things about that. Non-citizens, even if they're qualified aliens, and in some cases green card holders are, sometimes they're not, but sometimes they are. It depends on time limit and when they got here and stuff like that. But non-citizens are going to have to prove disability no matter what their age is. So that's one of the tricky things for SSI.
All right. I think let's keep moving. Hello?
More questions, or should I?
Sorry, I think my sound cut out. I said I think let's keep moving.
Oh, okay, good. So I just wanted to turn our attention to the problem of where a claimant has a drug addiction or alcoholism issue. They call this DA and A in Social Security lingo. And we think of it as the DA and A problem. And the reason is, this is the analysis Social Security does. Is the claimant disabled? If so, is the DA and A, is the drug addiction or alcoholism a contributing factor to the disability that is material? And if so, they deny the benefits. So what do I mean? If I am alcoholic and I suffer from depression, let's say, and my doctor says if I stopped drinking, my depression would vastly improve and I'd be able to function and work, I'm going to be found not disabled. If I am alcoholic and I have now, I don't know, cirrhosis of the liver that is on, I need a liver transplant. So whether I drink or not is not going to matter to the severity of my condition. Then I could be found disabled. So those are kind of how that works. But a judge needs a medical opinion to base the decision on. And I want to emphasize that too. A judge is not a doctor, and neither are we. So we need doctors' opinions. The judge needs to base the decision on medical evidence. So if we can help by getting medical evidence, that would be good. So one of the things that we can have, and the claimant can ask a treating physician to do, is give an opinion on these three questions if drugs or alcohol are an issue for that person, especially if it's not in remission. Even if it is, however, the physician can answer, is this part of the patient's history? Is it in remission? If the answer to 2 is yes, then good. This is not going to be a prohibition on finding disability. If it's hasn't stopped, the question is hypothetical. If it did stop or would stop, would the disabling condition continue to be marked or severe? If the doctor says yes, then again, the drug addiction or alcohol use is not a bar to a finding of disability, but we need a doctor to say so. And when I have a person who actively has this in their case. It's hard to win, but we at least get a doctor's opinion about this. Now, the thing about that is you hope the doctor has an answer that helps. And if the doctor doesn't have an answer that helps, but they have sent me a form, there is a rule that says I have to submit all medical evidence. I don't get to withhold it. So then I'm stuck with this unhelpful opinion. And you know, on one level, you can't win them all and you can't change the facts of a case. So I find that if a doctor does not want to give you a written opinion, it is often because they have nothing good to say. My mother, and probably yours, used to tell us as children, if you have nothing good to say nothing at all. So if a doctor is resistant to giving you a form, and you have a feeling it's because they don't have anything helpful to say, don't push them for the form, because once you have it, it has to be submitted. This is another issue that comes up. Just a word of caution. Sometimes clients have earnings records on file with Social Security that either we don't know about or they don't know about. So Social Security in the file will have this. It's very important to look at it, because if it turns up at a hearing that they have these earnings, sometimes it means they applied for the federal earned income tax credit. Sometimes it is, you know, fraudulent. Sometimes it's a mistake. Sometimes a family member convinced them to do it. Sometimes, as on the streets in the Bronx, starting at about March, there is somebody for Liberty Insurance dressed as the Statue of Liberty, handing out cards that say, "Are you on SSI and public assistance? You might be entitled to a tax refund." And that is not true. If you didn't work, there is no way you're entitled to a tax refund. But insurance companies say otherwise, so people go apply for an earned income tax credit, and an amount gets put down as earnings that didn't exist. So it gets to be a bit of a mess. It's good to know before you're before a decision maker. And there are things that can be done, like file amended tax forms, or correct those, or testify as to what happened. Even though we do not want to encourage anybody, two things. Everyone is supposed to tell the truth to the government, and we want to correct things going forward, but we do not encourage anybody to incriminate themselves to the government. So it's a little tricky, but we never tell anybody to lie. That may be another circumstance where if you have nothing good to say, don't say anything at all. You have the right not to answer. You know, if you have this specific problem, we can talk more about it. We kind of went over this, the non-medical eligibility criteria for SSI. So legal permanent residents can be qualified to receive SSI after 5 years in that status. There's more to say about that when you have a specific case, and I would have to look it up. A word about COVID assistance that people received that they're not receiving anymore, but just to know, it should not affect SSI eligibility or the amount a person gets. And they shouldn't be told they were overpaid because they received COVID payments. Social Security has sent people notices in error that they've been overpaid. For most of them, they're reviewing them all and correcting them. But if your client has something like that and they think, no, the only thing in the bank are my COVID monies, it seems that's a thing that could be corrected at the field office. COVID financial assistance. This is a list of most of the stuff that counts as COVID financial assistance. I don't know how much this is happening anymore, but I just thought I would keep it as a flag. I think we probably could do questions again because I'm going to go into talking a little bit about overpayments and what happens when a person is told they were overpaid. But if there are questions now, maybe we could entertain those.
No specific questions about what you just went over.
Okay.
I think, yeah, keep going.
Okay. So I just mentioned overpayments because I think that a lot of the people who are on this webinar have claimants who already are in receipt of SSI and maybe SSD, but probably mostly SSI. And the problems they face are either terminations because they are found to be no longer disabled, or they get notices saying they were overpaid for one reason or another. So I just wanted to touch on overpayments. A claimant should get a notice from Social Security. It should say you were overpaid and this is why we think you were overpaid, and it should give the appeal rights and the time limits for those appeals, which, so we'll talk a little more specifically. In order to appeal, one kind of appeal is where the person says they challenge the whole fact of the overpayment. I wasn't overpaid, or even if I was, it wasn't as much as you say. So that would be filing a request for a reconsideration of your decision, Social Security, that I was overpaid. And that can be done online. It can be done by a hard copy of a request for reconsideration form, and that is found online at ssa.gov. It's also found at Social Security offices. They don't encourage people to go into the offices if you can avoid it. And I kind of think the same thing, unless your client really can't negotiate it online or there's nobody in their lives that can help them do so. But, you know, you go to Social Security, you're still at risk for COVID in a crowd. You're going to wait a long time. Like, there are downsides to going in person. The other kind of appeal that a person can file is a request for a waiver of the overpayment. And that's where the person says, I know I was overpaid. I think it's true what they have, but it wasn't my fault that I was overpaid. And essentially, I can't afford to pay it back. And if you take back the money, you're going to render me so destitute that I won't be able to live, essentially. That can also be filed online. The request for reconsideration has a time limit of 60 plus 5 days. The request for a waiver does not, has no time limit really. And the idea behind that is maybe 3 years from now, after they've been recovering my overpayment, but there's still a lot to go, my financial situation has changed. And so I can no longer afford to pay it back. So I can file the waiver then. Something else I was gonna, if a request for reconsideration is denied or a request for a waiver is denied, there are also appeal rights where a person can ask for a hearing, and an ALJ can review and look at evidence and make a new decision as well. And that could be appealed at the Appeals Council, and it could go to federal court. So all those appeal rights attach. Does anybody have questions on overpayments?
Nothing on overpayments.
Okay, because then I think I have come to the end to say, here is my email address. And also, so if you had a current client who has a hearing coming, their application has been denied, or they're at some appeal stage for an application denial, a disability denial, I would love for you to refer them to us in any borough, because we have people in every borough who do this work. and we could take a good look at their case and see if we can represent them at the hearing. If you have a person who's not quite there or isn't your current client, then the public can call Legal Aid's Access to Benefits helpline. There's the number. It's Monday through Friday, 10 to 3. Same kind of problems. And it'll come through to us. It just kind of goes a slightly different channel. If advocates use my email address, that's manageable. I wouldn't suggest that you give it out to clients or the public at large. That gets to be unmanageable. But you could contact me with questions.
That's amazing. Thank you so much, Anne.
Okay, you're welcome.
So we have 15 minutes. How about getting into some of
Sure.
these questions?
Sure.
The rest of them.
Yeah.
Someone wanted to confirm that your services are for free.
Oh, they are. Yes. Legal aid services are all for free. It's a shame when people who have an SSI appeal go to a private attorney, because the private attorney, if the person wins, takes 25% of their retroactive money. And, that's how they make a living, but I don't make a living that way. So we just have a salary. So it's free. And the person gets all their retro, assuming HRA doesn't take some of it. Yeah.
Amazing.
Yeah.
Love legal aid.
Mm-hmm.
So what about overpayments resulting from hospitalization or rehabilitation?
Right. So if a person is on SSI and they are like at an inpatient facility that had provided for all of their food and shelter needs for more than 30 days, they're supposed to report it to Social Security, for one thing. And then Social Security will suspend their benefits until they're out of the hospital for 30 days or out of the facility for 30 days. And then they can restart the benefits, and the person should notify them. For a variety of reasons, a person doesn't notify them, or they did and Social Security never stopped the benefits. So overpayments in that case can be appealed. You should know that an overpayment, if the total overpayment is under $1,000, a person can file a request for a waiver and ask for really an administrative waiver. And anything under $1,000 should just be waived by Social Security. So that's a good one. If it's just like 1 month of benefits, they should totally file a request for a waiver, and Social Security should do it. And they do it pretty readily. If it's over 1,000, then you have to show your various points that it wasn't my fault. Maybe I was incapable of reporting that I was in the hospital because I was really incapacitated, and not being able to afford to pay it back. If I'm on SSI, the law says that is a per se level of income that makes you unable to afford paying it back. If you're on SSD, you're going to have to show your monthly expenses versus your monthly income. And if there's nothing left over after your expenses, that is a showing that you can't afford to pay it back. I want to say one other thing. For SSI recipients, at worst, if you file nothing, they will reduce your benefits by 10% until the overpayment is recovered, and they're not allowed to reduce it by more. SSD, their first thing is to say, we'll just stop all your benefits altogether until it's paid back. But then the person should contact them and say either they want to file an appeal, or can I make an agreement to pay this much so I could get the rest of my benefits. So there are things you can do. They just want their money. So, but arrangements can be made.
A lot of good tips in there. When arranging overpayments, how low can you negotiate to pay?
Well, for SSI, it's 10% essentially. But I think if you could show that that is going to leave me homeless or something, like whatever your rent is. But if you did 5%, I think you could make an argument. For SSD, sometimes it depends on the amount of the overpayment. If it's really an astronomical amount, then they're going to want more money. But so I've had them say, well, we want at least $100. But if I could show, and of course, before I have this conversation, or before your client has the conversation, they need to really assess their finances and decide, like, what is a real number? So could you afford $50? Could you afford 75? Could you afford 25? And if so, could you really show that all you can afford is 25? I don't think they'll go below 25. But it's very individual, and you'd have to make a convincing case that that is all I can do, but I will faithfully pay it. And because you don't want to make it a voluntary agreement that you can't stick to, because that just doesn't make any sense.
Okay, so I'm going back a little bit earlier from the session for some questions.
Mhm.
How can you go about opening up an investigation against a rep payee of a client?
Yeah, people, rep pays have obligations, and in Social Security's rules, they have obligations to use the money for the claimant and to not use it for themselves and not steal it and all of that stuff. So you can file a complaint. The claimant can file a complaint at their local field office to ask that the rep be investigated. If they had an alternative person that they wanted to suggest to be their representative payee, they could make that suggestion too. If they believe that they no longer need a representative payee, and if a doctor would corroborate that, they could get their funds directly. So I've had that happen where, whatever cognitive difficulty they had at one time, or that Social Security decided based on your disability, we're going to give you a rep payee. I've had a doctor, say, yes, she is treated for this mental disability, but she could manage her funds. And submit it to Social Security, and that person, started getting paid directly. It gets tricky when it's an APS thing, like APS thing. What does that mean? Adult Protective Services. I think they still have that acronym. Sometimes it changes, different points. But sometimes to get rent arrears paid, they had to have said, yes, I'll have APS be my representative payee. And then APS has problems. I don't know who's on this call, so I don't want to say something too derogatory, but their reputation is that there are a lot of problems there. And so, but if it was that they got rent arrears paid and under the condition that APS be their representative payee, sometimes it's harder to allege that they're not doing it properly and to get out from under that. So there are a number of factors which make it more or less possible to change rep payees. But sorry, I went a little far afield, but you can make a complaint and allege that the person is not being responsible and you want them investigated, and Social Security is supposed to do that.
And just real quick, I'm going to take care of a couple things on our end while we're all still here, and then we'll get back to the questions. So we're going to launch a poll. My colleague is going to launch that, and if you could fill that out. And then in the chat, we're going to put some of our upcoming events. We have a moment. All right, we have a training on the 14th about eviction prevention 1 year after the end of the eviction moratorium. We have a training on core, and we have a training on an overview of adult care facilities. So we hope to see you at those events. And then lastly, in addition to the poll that was just launched, we're going to share an evaluation survey in the chat as well. And there you can let us know what other trainings would be helpful for you. Okay, back to the questions. So when you someone was saying that when you receive SSI for disability, as soon as you turn 65, Social Security erases your history of being disabled. How do you prove your history for other purposes?
You know, it's an interesting question because I haven't known that Social Security erases your history of disability. But so I'm interested to know if that has been your experience, because they ought to still have disability records for you. But let's assume they do. If you need to prove disability for other purposes, it may be that Medicaid records could help, and a history of Medicaid, what services that Medicaid paid for, or pharmacy records that Medicaid paid for. And then maybe it also is something from doctors currently that can show that a person has certain impairments that render them disabled.
Thank you. If someone is about to retire and they end up getting fired without pension, does that affect SSI? And if so, will that person receive more money?
They're about to retire and they get fired without a pension. So I feel like there are a couple of issues going on there. SSI, as long as you're not working and you can't because of a medical disability, and you meet the financial criteria, you could get SSI. Like our clients with disabilities, yeah, I'll say it in an exaggerated way, they get fired all the time because they can't do the job. So that's not a bar to getting SSI. One thing though, if a person was working on the books and they got fired and they lost their private pension, it doesn't mean they can't apply for Social Security disability based on the taxes they've paid into the Social Security system. It's two separate things. I think you're talking about a private pension, which is entirely separate from whether you qualify for SSD or retirement benefits. So getting fired doesn't ruin your chances of getting retirement benefits. It's kind of not like unemployment insurance benefits, where if you're fired, you can't get them because you committed misconduct or something.
Right.
But I get why you would ask the question.
Okay, what happens when you receive SSI, but you need to be out of the country for more than a month?
Then you have a problem. You can't get SSI if you're out of the country for more than 30 days. And then you have to be back for more than 30 days in order to get it again.
Do you have to go through like the whole application process all over again? Or does it resume?
Good question. If you, if the time of ineligibility, because you were gone, is less than 12 months, then it can be resumed after 30 days that you're back. But if it's more than 12 months that you were ineligible, then you're going to have to reapply. Now, if you're 65 or older and a citizen, essentially, then it's just an age thing. So the application process is not as onerous. But if you have to prove disability, it's a drag. So it doesn't mean they're going to find you disabled again just because they did before. So if you can avoid it, restart make yourself eligible again within 12 months.
So yeah, we do have a lot of questions that are really, they seem like detailed and maybe we might need more information. Is that something people can email you about, or is that something people should call the hotline for?
Oh, the helpline is really for individual clients who have a problem we might represent them on. So they could email me. If the client themselves wants assistance also, they could also go to one of our singles, like our Robinhood partners.
Mm.
We get the cases then through Robinhood, and in the Bronx, that's Wedco and BronxWorks.
Great.
But you know what, so I'll say this, if people have questions in general, you could email me. If I find I have such a flood that I can't keep up with them, I'm going to let Tess know that. And we'll find
Good.
another method.
We're going to do the Ask a Lawyer session. So a lot of these we can bring over to that.
Yeah, that would be a great time.
You want to be mindful. Some of these seem really tough.
Yeah. Yeah.
But we're at time. And I'm sorry we couldn't get to all the questions, everyone, but I hope that this was helpful for you. And we'll be following up with another session so we can get into some of the questions. But thank you so much, Anne. This is really complicated stuff, and we really appreciate you reviewing it with us.
You're welcome. I'm happy to be here, and thanks everybody for coming.
Thank you. Have a great day.
Okay, you too.